Welcome to Packet 4. We will be discussing the packet that involves no children and no property. This is a simpler divorce if you have no children under the age of 18 that requires parenting plan or child support, and you have no property to divide, no assets or liabilities to divide. This could also work for people that do not want the court to be involved in dividing property. What you could do is you could agree that we've already divided all the property and we don't want the court to divide it. So this form will be also used for that. So I'm going to share my screen and we'll go over the form. All right, so as it states, this is no dependents or minor children or property forms. So we already went over the application for civil indigence, summons, process service. So number 4 will be where we're going over. Petition for dissolution of marriage will be the most important, and the final judgment. Those are the 2 forms that you will need because all the other ones that we've already gone over in packet 1. So this is the petition that you would have to fill out if you have no children and no property to divide. The first couple of pages provides you some information, but I'll be going over that. However, you could always go back and go through the instructions if you would like. Okay, so this is the form, and it's really short. So you're gonna write the top as you would your the circuit that you're in, the county that you're filing, the case number, and I would leave the division blank because the court will fill it out. And then you're the petitioner and the respondent is the spouse you're seeking for divorce. As the title suggests, it says petition for dissolution of marriage with no dependent or minor children or property, which means there's no children to have child support or time sharing or parenting plan. And no property means you have no assets or liability to divide. So as you look at the form, you're going to look at the jurisdiction. Remember we were talking about you have to be a resident of Florida for at least 6 months. This is where you fill it out. So you or your spouse or both has to have been at least 6 months. You will check whichever one applies to you. And you're also saying that neither one of you are in the military, or if you are, you would have to have filled out the affidavit of military service. You have to write the date of marriage. If you don't know the exact date, as long as you have the month and year, that's important. And the place of marriage, where you could write the state or county in the state or the country, wherever you got married. And then you're saying that there are no children, minors under 18 or dependent children common to both of you, and neither spouse are pregnant. And then you completed a notice of Social Security number, which we did in packet 1. And you're saying the petition of dissolution of marriage should be granted because in the state of Florida, there's only 2 ways you could get divorced. One is whether the marriage is irretrievably broken. And 2, if the other party has been adjudged to be incompetent for 3 years. And at this point in the state of Florida, we're in a no-fault divorce. So you could get a divorce, and that's what you will use. The marriage is irretrievably broken. However, if you have a spouse that's been adjudged incompetent, i.e. they're in a mental facility and or disabled and cannot determine for themselves, then you have to attach a copy of that order that says he's incompetent, he or she is incompetent. And also you're saying there are no assets or liabilities to divide, and that you and the spouse are both giving up alimony or spousal support. And if you change your name from if you are a woman, not for men, usually for women, if you got married and changed your name to his last name, you could have the opportunity to change your name back to your maiden name without having to go through a formal name change. So if you want to do that, you could write the name that you want to be used. It has to be your maiden name. And what it is you will get a final court order that says your name is going to be changed from James Doe to Jane Jones. And you take that court order to Social Security, DMV, etc., to get your name changed on all your legal documents. So you would need that court order, but it avoids you filing a separate action for name change, which is another $400 or $500 in filing fee. So this will help you if you're thinking of changing your name back to your maiden name. So now what you're doing is you're requesting the court to give you the divorce. And if there's anything else like restoring your name, or if you have any other request that you have. And this form has to be signed by you in front of a notary. So just briefly, if you have no property and no division, you could file your divorce using this petition. However, another way is if you're interested in simplified dissolution, there are some forms that you could fill out. However, through the simplified dissolution, you and your spouse both have to sign, notarize, and appear together at the final hearing. If you think your other spouse will not appear, then I will recommend you follow this route rather than doing the simplified divorce. So the next form we have for no property, no children is the final judgment. This is the only other form you need. And this form does not have to be completed by you. All you have to do is fill out the top. And what that is once the judge grants you the divorce, they will fill this form out. Because as it states, this is the final judgment. And what it is basically saying you have no children and no kids, so you just want the divorce. So the judge will grant it and they will sign this form, and this is the form that you will receive. So those are the only two forms you really need